Do you anticipate a need to expand the office with a potential need to hire a deputy attorney and/or a criminal investigator position?
No, I don't. If there's an expansion, I think it needs to be a paralegal or a secretary. Here's how I understand the current situation. First of all, we've only had a full-time county attorney with a high salary for a short while. John Flynn for years did this as a part-time practice while he also had his own practice and didn't have to. And so right now, the work habits and the hours of the incumbent, I don't believe that there's any real justification for a deputy county attorney. I expect to go in, pull in, put in long hours. I put in long hours in my job now. I expect to put in long hours and be the only county attorney. I will rely on MACO and some other expertise for civil stuff when I need it. I'll certainly rely on the state prosecutors for criminal expertise when I need it, but I don't think that there's a need to hire anybody. I mean, I would say give at least 2 years and assess it and come back, but I think it's highly unlikely that a deputy is needed. There may be a need in the staff, though, because of the way I understand it right now, there's a victims advocate who's half-time and then half-time with the court, and there's one secretary. And I think one of the ways that a lawyer works really effectively to get more done is to have an effective paralegal where you can do a lot of the prep work for a civil or criminal case. The lawyer can check on it and then come back and get end products. Now, a lady named Sherry Little used to be in the office. She was outstanding. She was chased away by the incumbent county attorney. I talked to Sherry Little and I said, hey, if I get elected, I would love to hire you. And she said, well, let me tell you, I don't want to work for a crazy person. But I can tell you that where I see that there may be a need is for a secretary or paralegal. I do not believe, I mean, it's really beyond what I think is foreseeable that there will be a deputy county attorney. As far as a criminal investigator goes, I think we need a better working relationship with the sheriff's office and their detectives so that we can work together on cases and we can sit down and go, we need to probably talk to this person, get this subpoena, and let's check back in a week and work on cases together cooperatively like that. And then the state criminal investigators are always a resource that we can use. So I'm not going to be going in asking for an increase in budget. The only thing I would look at is whether a paralegal, somebody of a Sherry Little type person would make sense. But I really think we need to try and keep our budget low because the costs in the county government have been going up. And I want to be part of the solution there, not part of the problem.
I would tend to concur. I knew John since 1991, and it was always a part-time county attorney position. And I was surprised when I did learn that it became full-time after John passed away. And John did it for so long, part-time. So I don't anticipate the need for a deputy myself. And Sherry Little was a huge asset to that office, and it's too bad that she left. And I would do my best to try to get her to come back because I'd worked with her over the years, and I know how valuable she was to John. So I don't think I'm going to need a deputy. I think one of the things that I would like to do, though, is hire a summer intern from the law school just to give some law students some experience. And there's a lot of kids who will do internships without pay just so they can put it on their resume and get a taste of it. As for working with law enforcement, I mean, law enforcement investigates. They're the ones who are out in the field. They're the ones who are determining probable cause determinations, and they're the ones who bring a request for a prosecution to the county attorney's office. And if there's some dysfunction or the people aren't getting along, the system's broke. Okay, and we got to put personalities aside, and we have to work together. Okay, and I wrote an article in the Broadwater Reporter, I think, when I made my announcement, and the case law, we call it. That's what the Montana Supreme Court, every week we get a new decision. And every year there's a wrinkle or a change in the criminal case law. And then we've got the legislature who changes the law. And we as attorneys have to keep on top of that. And I think it's our duty also to meet with the deputies and the sheriff as often as we can to discuss changes in search and seizure, changes in probable cause, changes in reasonable suspicion on stops. So without that relationship, the system is broken and it needs to be fixed. And I've been an attorney for 23 years. I've run my own practice. I've gone all over the state, and I've met attorneys all over the state, and I believe that I can work with whoever. And I can work with our sheriff now, who I know pretty well, and a lot of the deputies. So, but I think that is paramount, is we got to get that fixed. So, thank you.
What would you say your strongest asset and or experience, civil or criminal law?
I would say, I'm a litigator. Okay, so I would say most of my practice in the last 10 years has been criminal litigation. I was the Whitehall City Attorney for 8 years. It was a part-time position. I prosecuted all of the crimes that occurred within the Whitehall town limits. And the most challenging part of that job was going to the monthly town council meetings. And it got pretty contentious. We had a fist fight break out in one of our town council meetings, if you can believe that. But my biggest strength, I think, as an attorney is my litigation skills, and you get that by doing it. You know, from day one, I've been trying cases. I've tried over 100 cases. I tried in 2011, I think I tried 10 cases. I won 8 of them. The 2 that I lost are on appeal to the Supreme Court, and the other one is on appeal to the 9th Circuit Court of Appeals. I'm going out to Seattle on May the 13th. Now, this is a federal case, and I'm arguing before the 9th Circuit Court of Appeals, which is a pretty big deal for a small-town lawyer in Montana to have that opportunity. But my biggest strength, I think, is litigation. But I've also advised the town council in Whitehall, and there's a case called Town of Whitehall versus Priest, and it had to do with water meters in Whitehall, and we had kind of an uprising against that. It went all the way to the Supreme Court. I was a young attorney at the time, and I think Justice Turnage realized maybe I didn't have quite the expertise, so he asked the Attorney General's office, he asked MACO, and he asked bond counsel to file amicus briefs. But I argued that case before the Supreme Court, and the town prevailed. And but my biggest strength is litigation, and that's what probably 80% of a county attorney is prosecuting the crimes that occur within Broadwater County.
Okay, so my greatest strength at this point is civil law. I've done primarily civil law. I've done some pretty big cases. Represent the state of Montana right now in a case, Montana against Wyoming, fighting over the Tongue River. We tried a case, trial last fall. It was 25 days. We've spent, I think our budget is $2.5 million over the last 2 years, and it's just a massive case. Hundreds of documents, bunches of witnesses. I was in California last Thursday arguing our closing argument on it, and this is a case that's it's in the Supreme Court under a trial judge, and we're going to the Supreme Court next fall, so the U.S. Supreme Court. So it's a big case. I've done a fair amount of civil litigation. I'm new to criminal law. When I recognized that I wanted to take this, apply for this job and run for this position, in the job that I'm in now, I can do either criminal or civil law. I began asking for criminal prosecution opportunities. So I'm on 5 different criminal cases now. I'll probably have another 5 to 10 more by the end of the year. So I'll have done a few criminal cases, a few to jury trial. I don't have the years of criminal experience that Jack does. The difference is I haven't done any criminal defense. Most of Jack, well, at least lately, has been criminal defense, but he's done a lot of civil and city stuff as well. I think there's one other thing to think about, and that is not just the litigation and the criminal work, but it's the role of the attorney as an advisor. And I've had multiple clients that were an organization where you've got maybe 5 people on a board that don't disagree or that don't agree, and you're not the client for just 1 or 2 of those people. You're the attorney. I mean, you're the attorney for the organization, the entity. And so if they don't agree, you've got to work with that organization. In this case, it'd be the county commission with 3 people. You've got to work with them to come to decisions, resolutions, and moving things forward. And that's a whole different animal in itself. You have to work with the entity, the Broadwater County Commission, not just 1 or 2 of them. You've got to work with all 3 of them. And so there's a people relationship skill there that I've learned over the years from having to work with clients that are organizations where the board of directors is split. And I've said, hey, we have got to come to a decision here. If we have to lock ourselves in a room, work through our bad feelings, and ultimately come out with a decision that we can all live with, that's what we need to do. And that's a skill that I've learned the hard way with some knothead clients. And that's a skill that I think is going to be a big part of this county attorney job in the next few years.
As prosecuting attorney for Broadwater County, what do you consider the highest priority case that will come before you? DUIs, drugs, domestic, or other?
Well, I think the highest priority cases in terms of not only the visibility, but in terms of understanding the sensitivities are going to be violent crimes where someone is killed or someone is severely injured or there's some kind of a severe sexual abuse or something like that, because then you are dealing with not only just the severely hurt feelings of the victim, but you're also oftentimes dealing with a defendant that has some serious problems. You're not just somebody that made a mistake and got drunk and was driving home on a Saturday night. You're dealing with something that has the potential to impact many people for the rest of their lives. So when you get a case like that, and this is the way it works in our state, whenever you get a homicide or a serious aggravated assault or say a rape or a sexual abuse case, you automatically get your investigators and you say, let's call the best investigators of the state at the Department of Criminal Investigation, and let's ask them to help. And we call the prosecutors at the Attorney General's office who've done this, and this is specifically what they specialize in, is the homicides, the rape cases, the severe assault cases with serious bodily injury. And what you do is you don't bring them in, you don't dump the case onto them, you bring it in and you say, this is a high profile case, this is a high sensitivity case, let's sit down and really walk through all these issues so we know exactly how to charge it and exactly how to take care of the victim to not cause further harm. So that's probably your highest individual case priority. But what I've seen lately, and I've been going to a lot of the law and justice motion, law and motion days at the county here, what I've seen is in general what I would call my highest priority is actually going back and looking at all the cases that aren't being charged. There are a lot of cases right now in this county that are not being charged. And there are a lot of cases in this county that are being pled out at very, very low sentences. I was in a hearing where Judge Reynolds rejected 3 different plea agreements that the county attorney had reached with public defenders because he said they were too low. That is very unusual for a district court judge to do that. And for 3 in 1 day is nearly unheard of. Not only that, but the prosecutor was standing there talking like the defense attorney, saying, this person's got a job, they've taken responsibility. So the first thing I would do is go back and just say, do we have a mindset problem here that needs to be fixed, where we really need to go back and look at cases that aren't being charged? And do we really need to go back and look at some of the deals that are being offered and say, I don't think that's fair to the victims. And I don't think that's fair to the police work that's being done, and I don't think that's fair to preventing future crimes being recommitted by these people. So that would be my first priority as a general sense. But in terms of highest priority crimes, it's clearly going to be those violent crimes.
The Lewis case comes to mind. John Jardine, my mentor, it was his sister-in-law.
Do we have another one of these sheets?
Back in that case, and I've been involved in that, know about it since it had happened, and I understand what happened recently with Judge Reynolds' decision. But my priority would be sexual assault, sexual offense cases, because the damage they do to the fabric of our society and the cycle of dysfunction that permeates from that, but also violent crimes. Obviously, keeping our county safe is a #1 priority. DUIs are another priority. I mean, it's rampant in our society, and it needs to be dealt with. And I agree. I've seen, one of the reasons I'm running for this job is because I've seen prosecutors who don't prosecute because of a personal relationship or something, and then people being overcharged. And I've represented, I think, a lot of clients, regular, good, upstanding people who somebody got a personal vendetta going against them. And in some of my handouts, I talk about the John Luton case. John Luton was a businessman from Whitehall who became the target of a sting operation that lasted for 2.5 years. And we went through 2 different trials with the Attorney General's Office. Prosecutorial Services prosecuted that case relentlessly. We won at every turn. And then I was trying a case. I was defending a rancher down in Missoula County who was the victim of another sting operation by FWP, and I get a call from Nick Givok. He was a reporter at the Montana Standard, and he said to me, well, what do you think about your client Luton getting federally indicted And I said, well, that's the first I heard. He said, yeah, they charged him for filming a bighorn sheep hunt without a commercial film permit. And I said, well, is that, I had to go to the Code of Federal Regulations, and sure enough, that is a crime. And that's the case I'm going out to the Ninth Circuit. It was a Class B misdemeanor. Okay, and that's the lowest of federal crimes. Before the trial, he was charged with a Class A misdemeanor. At the pretrial conference, the AUSA, the U.S. Attorney, threw out the Class A misdemeanor. I thought, oh, we're halfway done. And Judge Strong turns to me and says, well, you know what that means, Mr. Morris? I said, no. It means your client's not entitled to a jury trial because it's only a Class B misdemeanor. Well, my client was convicted of that charge. And I'm going out, a month ago, the Ninth Circuit notified me that they're going to hear that case, a Class B misdemeanor from little old Montana, and I think we have a very good chance of prevailing. So, you know, I've seen it too often. This job takes discretion, it takes humility, it takes compassion, and it takes judgment. And that comes with time in the saddle, that comes with being in the courtroom. You got to think on your feet, and I'm pretty good at doing that.
Thank you. The question first is that
Okay.
Broadwater County did not have proper representation at the Department of Revenue case where taxable assessments were improperly made, resulting in budgetary shortfalls for the county. How would you ensure that the citizens of Broadwater County are properly represented in the future? Well,
this brings me back to when I was the White House City Attorney, and we got coal tax trust fund money and Treasurer State endowment money from the legislature to put in a new municipal water system. And for 2.5 years, we put public notices in the newspaper and posted them all over town, and no one would come. Finally, it's ready to go. We're ready to start construction, and they come out of the woodwork. Oh, you know, we didn't know about this. You can't be doing this. It takes citizen involvement. It takes involvement of all of the county government. It takes involvement of our citizens. And I think some people have been asleep at the wheel. That's just, again, I'm new to the county. But there's some issues that I think could have been prevented if they're brought to the attention of the right people. But we as citizens, we all have to be looking over and making sure our government is doing what it should be. I believe that government works best when it's closest to the people. And so all of us have a duty and I think an obligation to make sure that something like that doesn't happen again. And again, it takes everyone, not just the county attorney or the heads of the departments or the county commissioners. My job, if I were to be lucky enough to be elected county attorney, would be to advise the various department heads and also the commission on what the law is, not what my politics are, what theirs, but what the law is and what is in the best interest of this county. And I would do my best.
I'm moving over here at the request of the cameraman. I've watched a little bit about that case, and I know everyone was completely caught off guard by the assessment that came down. And you need to know, it's not like no one's ever been surprised by a tax ruling before. So I mean, there's some amount of that you've got to work very hard and you've got to do the right analysis. And sometimes Department of Revenue just does weird things. I don't think that's the case in this particular instance, though. There are a few different areas of law that you have to do what Jack suggested, which is proactive education and then proactive going in and screening your actions and your records rather than waiting for a problem to come. One of them is the taxation and all the property assessments. Another one is the human resources management, the area of how you manage your employees. Anybody who's ever run a business with more than 2 employees has taken the time to go in and look at the laws and look at the rules and set up. A lot of it's determined by your own employee handbook. You've got to set that up and make sure that it follows the law. That's complicated stuff. And that's stuff that I'm not an expert on. You're going to run into stuff that the lawyer's not an expert on. So you go get the experts. You go to MACO and you say, your human resources person needs to come down and not spend 1 hour, needs to spend 2 or 3 days with us and working through all this, and then come back in a month and spend 2 or 3 more days. that kind of hard work on the front end is going to prevent some of the fights and the clashes that we've had on the back end. And I think the same thing goes with property assessments. We actually have to go in and analyze what the county is doing, and analyze the mills, and analyze it by even different districts. We have a leak district, or a fire district, or a road district, or sewer district. The other area that's a problem are dealing with roads and easements. And I can tell you right now, Broadwater County has a lurking problem. Every county in the state is supposed to be working through DNRC right now to analyze their roads and apply for historic easements and rights of way. And they go to the DNRC. It's a simple process. They go to the land board approves them, and they're done. Well, there are some counties in this state who have already done 40 of these historic easements and rights of way. And I was really curious about this the other day because I work for the Attorney General and I advise him on the land board. And so we looked at this one from Prairie County. So I called up the DNRC staffer and I said, hey, how many of these from Broadwater County have you got? 0. And the deadline is 2017 to have these complete. So in the next 3 years, Broadwater County is supposed to go through and analyze all of its roads and find out where it doesn't have an exact easement or right-of-way on state lands, and then it needs to go apply for an easement. It's not a hard process, but if you don't do it, it's pretty hard. And so that's another example where we have to go through and just to analyze all these different areas of county government and county operations, and then do proactive work on the front end, rather than afterwards going, oh, we didn't know about this.
What does the supremacy clause mean to you? We're all interested in that.
So the supremacy clause is a clause in the United States Constitution that says that this Constitution is the supreme law of the land. But it doesn't mean what everybody thinks it means. It doesn't mean that every federal law is the supreme law over all of us. It is a supreme law within the area and powers of the federal government that the Constitution gives it the powers to operate. There are many areas in the law that the federal government has nothing to say about. It is the state law that decides. And in those areas where the federal government, by the United States Constitution, has no authority, the state law is the supreme law of that land. And that is something that's continually confused, and that's why we have the United States Congress that just keeps giving itself more and more powers and keeps passing more and more laws that are well beyond the authority that the United States Constitution gave the federal government. And they're now messing with the states. And so in my job as a Deputy Attorney General, I spend a lot of time litigating against the federal government. And one area that's very common is regulations by the Environmental Protection Agency. And we deal with fighting against federal EPA efforts to come and regulate the states where they don't have the authority to do that. It's the state's authority, and the state's authority should be supreme. Now, there's also some federal laws, like the Clean Air Act and the Clean Water Act, where they have what's called cooperative federalism. And it says the state's authority is supreme in these areas so long as they don't do these pollutions that go across state lines into another state. And the EPA is continually trying to ignore that and tell the states individually what to do. So that's an area where I've become familiar with the supremacy clause, because I recognize that in areas, now let's say you're talking about federal taxation, or you're talking about armed forces, or you're talking about some of those specific things, the federal law and the federal Constitution are the supreme law of the land. But there are some areas, local government, police power, schools. The federal government is supposed to leave those authorities to the state. And in that area, the state actually has a supreme law of the land.
My understanding of the supremacy clause is it comes from Supreme Court decisions over the years where the federal government has supreme authority and there's federal preemption on different things. I don't necessarily agree with that, but that's where it is. I understand the Bundy case down in Nevada. You know, you hear about that, but then when you put it into perspective, why in the heck does the federal government control 89% of the land mass of the state of Nevada? You know, rationally that, but it does. And there's court orders that have been in place down there. But the supremacy clause, I don't think it's going to affect my job as the county attorney here in Broadwater County. I've had my run-ins with the federal government. I don't know if you know this, but if you overpay your quarterly payroll taxes to the federal government, you get penalized. I did that. That happened to me. I thought I was going to get a refund, and I got a couple $1,000 fine because of a arithmetic error that my secretary made, and we overpaid our quarterly taxes, if you can believe that. So the supremacy clause, it is the law of the land. The way I think the original founding fathers looked at the way the Bill of Rights and the Constitution were written, anything that wasn't specifically specified as a power to the federal government was left to the states. Well, over the last 220 some years, that's been eroded away by court decisions by the United States Supreme Court, and we're stuck with that. But it's slow, it's glacial. The law changes slowly, and that's one of the geniuses of our country, is due process and constitutional rights are inconvenient, and they're supposed to be. And that's why things change slowly, but when they do change, they usually change for the better. And I think the pendulum is starting to swing back to letting the states regulate what goes on within the states. So I'm not a big fan of the supremacy clause, but it is the law of the land. I had the opportunity to get sworn into the Supreme Court when I was a young lawyer, and I had tea with Chief Justice Rehnquist before I got sworn in because of a connection I had, and there was an en masse swearing in, and I had a seat at the front row, and I was the only guy out of 300 people who were getting sworn in who got to stand up and raise his hand, and the Chief Justice Rehnquist swore me into the Supreme Court, and he loved the fact that I was a small town lawyer from a small state in the West, because he started in Arizona, and he moved eastward to rise to Chief Justice. But the supremacy clause is the law of the land, and again, it changes, and I think it's swinging back, where it's out of balance, and it's starting to swing back.
Okay, I think this could probably be a yes or no question. We'll see. Do you see any potential problems representing both the city and the county?
No, I don't. I mean, prosecution of the crimes that happen, the city only has misdemeanor jurisdiction, the city court judge and the city, and the county obviously has felony jurisdiction. So I don't believe that there's going to be any problem. A lot of small towns and small counties have interagency agreements where the county attorney does represent certain municipalities within a county. So and it's based upon economics. You know, not every town can afford a full-time county or city attorney. Dillon comes to mind. They have a full-time city. They have two. And I couldn't believe what they were getting paid. I got paid $500 a month when I was the city attorney in Whitehall when I first started out, and that was for everything. I got a raise after 6 years to $750 a month. But after 8 years, I was making enough money where I didn't need the help to pay my overhead. But no, I don't see any problem whatsoever.
I think there's potential for problems, but I think you can avoid them or you can deal with them. And I know there was a problem this year where the county attorney, who's also the city attorney, in terms of advising the town council, had reached a point where there was a city policy and there was a county policy, and I won't go into all the details because I don't know all of them. And she said, well, my first loyalty is to the county, so I can't advise you on this. And I think that's the wrong answer. The city is paying part of the salary of the county attorney, and they need to expect that if they pay for that work, they're going to get that work done. So I think that the county attorney, if he or she can't work through that potential conflict, then the city should be justified in asking for a refund of the salary and hire somebody. But I think that is something that doesn't need to happen. I think it's avoidable because a lot of these issues come down to, again, personal relationships and a matter of analyzing a problem. And specifically when you deal with city-county planning jurisdiction, that's likely where you're going to see that happen. Then what the attorney has to do is clearly lay out to both clients what point A and point B are and where there may be a conflict. And you can represent clients that have conflicts so long as you inform them. You have to talk to both entities, not just one over the other. To both entities, you say, here's the potential conflict in the advice you're asking me to give each of you as clients and as entities. Here's plan A, here's plan B. I can continue to represent both of you and give you advice so long as I have your informed consent. And they actually say, yes, we understand there may be a conflict. You've advised us of the potential conflict. You've advised us of the two different points of view and the course of action we can take. And they sign it and say, we approve. Keep representing both of us. And then you work through it with a whole lot of finesse and humility and patience, and you continue to represent both of them with everyone's eyes wide open. You don't say, sorry, I represent the county, so city, you're on your own. And you don't say, oh, no, there's no conflict here. Everything's fine. Everything's fine. You be very clear and upfront to everybody, and that way everyone understands that you're being honest, you're being direct, you actually know what you're talking about, and this is not the end, and we're not burning bridges. We can continue to work together year after year.
Okay, it's time to ask each other one question, and it's 3 minutes. So, let's see, well, Jack can ask first, since Cory started first.
I guess, Cory, just the question I'd ask you is, how much experience do you have actually prosecuting crime? Because that is about 80% of the job here is knowing this is this is my Bible here. This is Title 45 and 46. This is the criminal code of the state of Montana, and I use it every day. So I guess the question is, how much experience do you have prosecuting cases so far in your career?
So yesterday, I was all scheduled to do a jury trial prosecuting a DUI. The defendant, 15 minutes before we started bringing the jury in, the defendant said, I'm really hurt, I've got this problem in my back, I can't stay, and the judge said, okay, we're going to continue for another time. Now, had things worked out differently, I would have said, hey, I prosecuted a criminal case all the way to a jury. So today what I can tell you is I came really close. But Jack raises a fair point. I have not done a lot of prosecution. I'm currently counsel on 5 different criminal cases, and I have 3 more that are in the wings that I'm about to do. That's what I mentioned at the beginning. I think by the end of the year I'll have 10 to 12 criminal cases, many of which will settle, a couple of which will go to jury trial. And so I don't have years and years of criminal law experience. I recognize that as a weakness, and so what I've begun doing is I've begun working with deputy county attorneys, working with prosecutors in the AG's office, working with investigators, and saying, here are the areas I need to learn. I'm looking at mental commitments. That's something the county attorney has to deal with. Dependent neglect, dealing with children and difficult cases involving children. That's an important area to deal with. Just going through the general charging process, all the way through the post-conviction process. And so I'll have done enough of those by the time this year is done, that I'll say, okay, I've got my feet wet, and I know it's this first year, I'm going to have to be working and drinking like a firehouse. Truthfully though, it's not like I fell off the turnip truck last night. I've been trying cases, and I've been a civil lawyer for 5 years. This case that I tried last fall is the biggest case that the Department of Justice has had in 25 years. And we are going to the U.S. Supreme Court. We'll be in the U.S. Supreme Court next fall. So I've done the trial work. I've done witnesses. I've done lots of evidence. I've dealt with judges and opposing counsel and motions. I've got all that stuff. Nobody has it figured out. You're just continuing to learn. But Jack raises a fair point. But one thing I will tell you that I question in terms of, and I'll ask Jack this question in a minute, is that I also, Jack is a guy who has spent most of his time defending criminals, and we've heard it tonight, defendants, criminal defendants. And we've heard it tonight when he said repeatedly that prosecutors are overcharging cases. Now there's some crazy cases out there. The bighorn sheep that he talked about, that case should have never been charged. That was, in my opinion, the FWP should have been held liable for that one. But in general, the problem we have in this county isn't undercharging cases. It's we're not actually taking these cases that need to be charged all the way through and getting fair results. And that's what I want to focus on. It's going to be a learning curve. I know John Flynn was a very young guy when he came in and took over this job. And I believe I've got the experience and I've got the attitude and the humility to go in and say, I'm going to learn every day and you can be happy with my work.
My turn.
All right. Okay, I don't understand.